Welcome to Florida is Our Domain.
Welcome back to Florida is Our Domain with Anthony Policastro. Tony is a Florida eminent domain attorney and the founder of Policastro Law Group. With over 30 years of experience in the field, he represents national corporations, business owners, and individual landowners across the state. I'm Kevin Rosenquist, and in today's episode, we're talking about how eminent domain affects auto repair facilities, from parking lots to circulation issues, and the steps required to keep those properties functional. Tony, good to see you. Welcome back.
Good to see you, Kevin. Thank you.
So automotive repair sites often rely on several moving parts: customer parking, repair bays, storage, delivery areas. I mean, they've got to store the cars somewhere when they're not working on them. So that's a whole thing too. When a taking reduces the size of the site, which of these components tend to be impacted?
So it all depends. What is impacted depends largely on the taking itself. Where is that taking located, and the depth of the taking, because that's what will ultimately drive the impact on the property. Everything will flow from that taking.
Last episode, we talked about gas stations and C-stores, and kind of like those, there's always some nuances as far as entering and exiting an auto repair shop. There might be a lot of cars around, depending on how busy they are and all that stuff. What types of experts or technical evaluations help you understand whether the property can even continue operating as intended after the taking?
Well, as always, the key is the civil engineer. So they're involved in the case. Can also be a land planner, and they can be helpful as well. It's also, important to take a look at how it's laid out in before how things function. So, for instance, I've represented a lot of auto repair places that also have other components to them. So they might have U-Haul rentals, for instance, as well.
Yeah.
So there's going to be other things going on, and it all depends on how that taking is going to affect the auto repair, but could also affect other components to the overall business. But besides the engineer and the land planner, certainly a fixtures and equipment specialist, and certainly a real estate appraiser. And again, if they meet the 5-year requirement of being in business, you would have an accountant as well.
I know that you've had a jury trial involving an auto repair facility. I'd love to learn about that, because that seems fairly unusual to go to trial, right?
Well, it is a little bit more nowadays, but I've had about 10 jury trials in my practice. So I've probably had some more jury trials than a lot of folks out there in eminent domain. But in this particular case, it was property in Arcadia, Florida. The taking was a little bit under 5,000 square feet. It was a corner clip. The owner, and he was the real estate owner, him and his wife, along with, so they were running the business. They owned the real estate. They they had different components. It was very interesting to the property. So they had the auto repair, right? But they also had a towing business. And they had fenced in areas where they would impound the cars until the insurance could get out there and take a look at the cars. So they were storing a lot of cars on site in a couple of different impound areas, if you will. And then they were working on cars. And then another part of the property, they were renting trailers, U-Haul business, essentially. And then they also had a major contract with the sheriff, and they're working on all the sheriff's fleets of cars as well. And then they were towing cars in and out all the time. So there was a lot going on, and DOT thought, this was just a very small taking, and they didn't understand.
5,000 square feet? That doesn't seem small to me.
Well, it was a corner clip. So they were thinking it wasn't much. And so they just, really didn't negotiate much off of their number. And that's usually when you get a jury trial, is when they're not willing to move much off of what they think their position should be. So we wound up trying the case. So it was very interesting, and we got a very favorable jury award. Certainly got the client more money than he was ever offered by the condemning authority.
When these kind of situations go to trial, is there ever a situation where the I guess the taker, the person, the group taking it is told they can't, or is it always allowed in some sort of way?
Well, remember, it is a two-phase approach. So in that case, and in most all cases, the judge is going to decide the taking. So he or she, the judge will decide whether or not the condemning authority has the lawful right to take the property. And once he determines that, then ultimately compensation is up to a jury. So if the parties can't negotiate a settlement or mediate, then it can go to a 12-person jury in Florida. And again, one of the most interesting things about Florida eminent domain law is that you have a 12-person jury. And the only time you get a 12-person jury in Florida is if it's an eminent domain case or the death penalty is involved. Everybody else also gets 6 people. And I think it ties in nicely to the fact that Florida reimburse or pays for the property owner or the business owner's attorney's fees and reasonable expert costs. So it all sort of ties together neatly. We're a full compensation state. If you had to pay, obviously out of pocket for your attorney and your experts, you wouldn't be fully compensated. And also with the jury trial system here, you do get a 12-person jury, which I think tells you how much they value your property rights in Florida.
So it would seem to me that the condemning authorities would probably not want to go to trial, right? I feel like that probably would favor the plaintiff or the business.
I think yes, in the sense if they are factoring in the costs of trying the case, what it would cost their side, the property owner or the business owner's side. But you still have trials. You have less now, I think, because a lot of cases settle at mediation. Mediation is mandatory now in Florida. Yeah. It at one point wasn't. There were more trials that I had towards the beginning of my practice than I currently do now. A lot of things tend to settle out.
Yeah, I feel like that makes sense. I mean, mediation, I imagine, would be a really good tool for this situation. In your experience, how does the loss of maneuvering space affect daily operations at a repair shop, especially when vehicles need to be, moved in and out of the bays throughout the day?
Right. I mean, I can tell you a case I had many years ago, which was very interesting. It was auto repair. He did air conditioning and heating in cars, and he was a terrific gentleman. Very, very, very nice family. The daughter worked in the business. The wife worked in the business. Their place was always packed. And so literally there wasn't really any maneuvering because they were just literally having all the cars parked outside and then moving them into the bays, then moving them back out. There wasn't really a lot of room. And I can tell you, it was one of the rare instances that the condemning authority, in this case, it was the Department of Transportation, they paid the entire claim in full at mediation. They didn't negotiate down.
Wow, so that's got to be unusual.
Yeah, that was very unusual. But yes, he had an extraordinary business. And once that business was presented to them, and how he literally, and how you prove this too is not just with pictures, but again, with the engineers, they'll often set up cameras on site and maybe do a week worth of video. And you can see how cars enter and exit the site, how much usage is done. So those are all really important elements to prove up your case.
I would imagine an air conditioner repair in Florida does pretty well.
Well, it's for cars. So
yeah, but still.
Yeah, it wasn't just air conditioning, but yes. Yeah, he did very well.
When parking is eliminated or shifted, what are the biggest operational challenges that it creates for the shop and its customers?
Well, first of all, you're losing space, right? So you're losing money. So that's, a big issue. And then if you're trying to recapture that space, the question is, hey, how do I recapture that parking? And literally, if we've suggested before where you can cut and reface a business, say on the side of the business in order to get more customer parking back. But then again, you're sacrificing interior space. So do you need that or don't you need that becomes the question. So those are things that you face. But yes, sometimes you're just going to, be taking the hit. So that's when you're going to be asking whoever condemns the property, whether it's the DOT, a county, a city, whomever it is, to basically pay you for your loss because you can't fix the problem. If you lose a row of parking, and this goes for, say, used car lots as well that I've dealt with. If you're, parking is such a premium, and if you lose the parking spaces and you're filled, most of the time with cars, then, how do you recapture losing 10, 12, 15 parking spaces? You really can't do that when, you're parking. You may not have a lot of parking. So, you may lose 10 spaces out of 20. Well, you've lost half your parking. You lose half your business. You're going out of business, right? So,
You've had matters where internal circulation had to be redesigned after the taking. What kind of problems show up when the remaining layout just no longer supports the original workflow?
well, again, that it comes down to making choices, right? And sometimes they're just horrible choices to make. Is, for the business owner to decide, when that traffic flow isn't good. Going back to that case I talked about in Pinellas County in the last episode with the gas station, it's, are you going to be eliminating something? So will you be eliminating a fuel pump in that case? And in the case with, auto storage, you want to get circulation back, but does that mean you're going to be eliminating more parking or parking uh, in order to get, site circulation back on your site? So it's very difficult, or again, you're going to have to face a loss of business because you're not going to be able to fit everything back on that you were in the before. So, if you lose 10% of your business, how does that calculate out to a business loss and damages? And of course, there's always a tipping point. Any accountant will tell you that as, you lose 10% of your business, 20%, you could lose 30%, but then you've lost your business. You can't continue to operate because, profit margins, and that's where you're, taking a look at. So yeah, it can be very tough. And these are very, impactful things that can happen to people. And it's their livelihood. It's their supporting their families, a lot's going on with it. And it's very emotional for these people that are, having significant takings. So, that's where we hopefully come in and try to either get them paid or try to figure out a fix and a cure to the problem and have the condemning authority that caused the problem pay for that problem, pay for fixing that problem.
When the owner and when the business owner and the retail, the landowner are different, how is it determined who is getting compensated?
Well, the business can only get compensated for the business loss. The real estate owner gets compensated for everything tied to the real estate. So they're getting paid for the land taken. And an interesting question is the improvements in the area of the take. Who owns those? Does the owner own them or did the tenant put them in? And whoever owns them should get paid for that. Severance damages to the remainder property um, are paid to the real estate. But again, the caveat is what sort of lease is there? How long-term is the lease? So when you're dealing with, say, a large anchor tenant that has, Publix or something like that, that's got many years left on their lease, will they be entitled to an apportionment of those real estate proceeds? So that's something to take a look at with the leases. Is there a discussion in that lease of if an eminent domain matter happens, who gets those real estate proceeds? Is there an apportionment for the business to get some of that real estate. In most situations, what's common is the real estate owner gets all of the real estate compensation, and the business owner has a separate claim, and they get paid for their business loss. They can also get paid for fixtures and equipment they may own on site as well. So that's the norm, but I just wanted to bring up that there is some subtleties sometimes where, especially in a long-term lease, the business tenant could have a right to get some of the proceeds from the real estate settlement.
Mm-hmm. That sounds right. Yeah, complex situations for sure. All the more reason that you need an eminent domain attorney on your side. All right. Well, thanks for listening to today's episode of Florida is Our Domain. If your property or business is being affected by a public project, visit policastrolaw.com to schedule a consultation and learn how Tony and his team can help. Don't forget to like and subscribe and leave us a review. We always appreciate that very much. Tony, I always appreciate your time. Thank you so much for being here.
Hey, thank you for your time, Kevin. Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.